other boats. Stormy weather and drowning industry vessels and oil rigs present additional risk of crashing, injuries from heavy machinery, burns from fires, and explosion harm from falling objects, falls from elevated heights, respiratory problems from breathing in hydrogen sulfide, and more. Many such maritime injuries or illnesses are survive requiring extensive medical treatment and prolonged periods away from work. The only thing keeping an injured maritime worker from extreme financial hardship is often the protection provided by maritime law. In most maritime injury cases, this involves making a claim under the Jones Act. The legal rights of injured maritime workers. Offshore workers are primarily protected by the Jones Act, which is similar to the Workers' Compensation, a law that applies to land based accident victims throughout the US as long as your maritime injury occurs on the high seas or in navigable waters. Your case may be covered by the Jones Act. The high seas are bodies of water outside of state jurisdiction, and navigable waters are recognized highways for commerce running access bodies of water between states and countries. The Jones Act, also known as the Merchant Marine Act, is over a century old and protects eligible injury maritime workers in two main ways: maintenance and cure claims. No matter how your husband maritime injury was cased, you may file a maintenance and cure claim under the Jones Act. The maintenance part of the claim obligates of your employer to compensate you for lost wages. They must cover your daily costs of living while you are recovering the unable to work. The cure part of the claim obligates your employer to cover all reasonable medical expenses resulting from your injury while you are still in service to the vessel. A maintenance and cure claim is a no fault solution, meaning the employer must compensate you for this cost no matter who was responsible for the accident. The limitation of maintenance and cure claims in an effect in an effort to keep cost as long as possible. An employer may fail to provide the significant maintenance payments to compensate you for responsible living costs. If you find this to be the case, a hostile maritime injury lawyer may be able to gain you a higher maintenance payment. Also, following an offshore injury, an employer may seek to pursue the injured worker to see the company doctor, but as the maritime accident victim, you have to see your own physician who may offer a higher quality of treatment, maximum medical improvement. Victims of a hostile maritime injury also sometimes encounter another problem under admittedly law, but maintenance and cure must only be paid until you reach maximum medical improvement. This is the stage at which it is deemed that your injury cannot improve further even with additional medical treatment. Once you reach maximum medical improvement, your employee's payment will stop and you will need to pay for any future medical cost is out of your own pocket. When you are had a serious accident with survive maritime injury sustained, this might be discussed. It's therefore advisable to speak to an experienced maritime injury lawyer before undergoing the scheduled doctor's visit with your employer's company doctor to determine if you have reached maximum medical cure. Even before filing your claim, a hostile maritime lawyer can advise you on how best maximize your compensation. Filing a lawsuit under the Jones Act In addition to maintenance and cure claim, in some situation you can also file a lawsuit for additional compensation if your employer was responsible for your maritime injury because of negligence. You may be able to file a lawsuit to win greater compensation for your losses. With a lawsuit, you may be able to pursue more damages for your medical bills, lost lost wages, and reduced capacity to work. You may also be able to recover non-economic damages such as pain and suffering, emotional distress, ability, physical improvement, and loss of life. A successful maritime negligence lawsuit under the Jones Act requires proof that the employer was wholly or at least partly responsible for your accident. Proving this will often require an experienced maritime injury lawyer for difficult court case, cases. The best maritime attorneys are usually national travel lawyers with extensive experience trying maritime law cases in federal courts.